It's a historic decision. It codifies what we already knew in the international legal community, but it gives this further support and authority because it has been effectively decided. That gives real support now to the struggle for Palestinian liberation, another stepping stone toward ending the root causes of the situation in Palestine, being apartheid, colonialism, now genocide.
This is the Mondowise podcast, and I'm Khadr Jabbar. On July 19th, the International Court of Justice, or ICJ, ruled that Israel's occupation of Gaza, the West Bank, and East Jerusalem is illegal and must end immediately. Palestinians, of course, have been saying this for years. The court stated that Israel must halt all new settlement construction, evacuate settlers, and pay reparations to Palestinians, calling some of Israel's policies apartheid. This advisory opinion, requested by the United Nations, marks a significant condemnation of Israel's legal defenses. The ruling emphasizes the occupation's illegality and highlights the need for international accountability and policy shifts. This historic ruling, though non-binding, challenges Israel's legal defenses for the first time. Palestinian Authority President Mahmoud Abbas celebrated the decision as a victory for justice, while Israeli Prime Minister Benjamin Netanyahu dismissed it, calling it absurd. The United States responded by affirming only that Israel's settlements are illegal and criticized the breadth of the court's opinion, which it said will complicate efforts to resolve the conflict. I'm joined today by Craig Mukhbir, an international human rights lawyer and activist, and a former senior United Nations human rights official. Craig served at the UN for over 3 decades, with postings in Switzerland, Palestine, Afghanistan, and New York, conducting numerous human rights missions across various continents. In October 2023, he left the UN, criticizing the organization's human rights failures regarding Israel's actions in Gaza, warning of genocide in Gaza, and calling for a new approach to Palestine and Israel based on international law, human rights, and equality. Welcome to the Mondowise podcast, Craig.
Thank you very much. Happy to be here.
So, Craig, can you explain the ICJ ruling on Israelis' settlements? What's the big deal here? What should people know?
Well, it is a very big deal. This is, after all, the International Court of Justice, the World Court, the highest court of the UN system, of the international system, from which there is no appeal. And its advisory opinions are definitive, authoritative statements of what the law says and what the law requires. And there's no appeal from this. So this is now a matter of settled international law. Its implementation, of course, is going to rely upon the conduct of states. And I would say on the conduct of all of us, and we can talk a little bit about that, but principally on the conduct of states and of international organizations like the United Nations. They have to put in place measures, because these are not self-implementing decisions by the court. Now, you've said advisory opinions are not legally binding. That's true in the sense that they don't command a state like Israel to take certain action. What they do is they articulate what the law requires that state to do. But it's not entirely true to say that they are non-binding either, because, as I said, this is an authoritative statement of what international law requires. Some of the rules of international law that they identified are so-called erga omnes. It means that they are rules that impose obligations on all states. So they're saying, look, this is already an obligation. In that sense, these are binding obligations, erga omnes obligations. Things like the non-acquisition of territory by force, things like not interfering with the right to self-determination of the Palestinian people. Those are binding rules of international law that the International Court of Justice has now declared are in effect. And it's also binding in a common sense way on the United Nations. It is the United Nations, through its General Assembly, that requested this opinion from the court under the UN Charter and the statute of the court. And now it can't ignore what the court has determined to be the requirements of international law. So, you hear this phrase of non-binding thrown around a lot, but it doesn't mean that the laws that have been articulated by the court are not binding. They are. International law is obligatory. It's not optional on any state, on any member state of the United Nations, on any of the treaties to the parties, to any of the parties to the treaties that are cited, or when it comes to customary international law, also invoked by the court in this advisory opinion. Those things apply to all states as well. So it is a very important development. It is important first because the court rejected all of the objections of Israel, the U.S., and its other Western allies. Objections to whether or not the court had jurisdiction. The court ruled very clearly it does have jurisdiction to determine this. Objections about the court's discretion, because the argument by those who were opposed to the court taking action was that, you may have jurisdiction, but you shouldn't rule on this because you should leave this to the political process. Don't get in the way of our negotiations. And the court, rejected that entirely and said, no, international law has to be applied. And then the scope of what the court decided in this advisory opinion is really quite striking. They ruled that the Israeli occupation of Gaza and the West Bank, including East Jerusalem, and all settlements are entirely unlawful. No equivocal language on that. All of that is entirely unlawful. Now, we knew this in the international legal community, in the international human rights community, but again, this is the World Court, which is laying this out in a legal document once and for all. They also declared that Israel is committing racial segregation and apartheid in the occupied territories. Now, again, we knew this in the international legal and international human rights community for many, many years, but this again is the World Court making this observation. And they said that what flows from this is that Israel is obliged to evacuate all settlers, dismantle all the settlements, dismantle the wall in the West Bank, to provide reparations to Palestinian victims, to allow all Palestinians who were forced out to return to their homes, and that all other states, not just Israel, but any other states that are providing any kind of aid or assistance to the occupation must cease that aid at once, and they must use all of their influence to ensure that Israel complies with what the court has said and ends the occupation. And I think another really important and historic thing that happened here, which is paradigm shifting, is that in the course of issuing the opinion, they said that the Oslo agreements and that entire Oslo paradigm do not and cannot trump the obligations of international law, which oblige Israel to do certain things and protect the rights of the Palestinian people. This is important because for more than 30 years, you've had the U.S. and others, the UN complicit in this as well, I would say, in pushing the rights of the Palestinian people and the international legal guarantees of those rights off on the back burner while they talked about this amorphous political process of Oslo. And the court says, no, we don't defer to agreements between occupier and occupied when it comes to the rights of the Palestinian people. And we don't defer to the politics of the Security Council. International law here takes precedence. So this is what I mean by a paradigm shift, because for more than 3 decades, we've been focused on this political process, which is, let's face it, has done nothing to deliver protection or justice or the rights of the Palestinian people. And in fact, has created, as I've said, a kind of a smokescreen behind which you've seen continued dispossession, persecution, settlement activity, and so on. So this is really important because now the UN, and if they want to be law-abiding states, all states are going to have to prioritize the rights of the Palestinian people under international law and the obligations of Israel under international law over any kind of political process. So that's it. That's the statement. The occupation is entirely unlawful. It must end quickly and totally, which means every settler, every soldier, every occupation law that's been extended to the people in Palestine, every policy, every so-called fact on the ground is unlawful and must be removed. The other thing that I think is interesting about this is that across the court, the court is made up from judges from all around the world, different legal systems, including many from the West. And every decision that it made in this advisory opinion had overwhelming support across the court. It was a massive majority. It wasn't a close call at all. You have one judge on the court called Judge Sebatinde from Uganda, who always votes in favor of Israel, who drafted a dissenting opinion, which is really quite extraordinary. Not very well rooted in established understandings of international law when it comes to occupied Palestine. But it was a real outlier, and I would say kind of crazy if you actually read the dissenting opinion as I did. And then you had some different understandings of some of the points by some of the other judges, but overwhelmingly, including the judges from the West, they supported this advisory opinion. So it's a historic decision. It codifies what we already knew in the international legal community, but it gives this further support and authority because it has been effectively decided. That gives real support now to the struggle for Palestinian liberation, another stepping stone toward ending the root causes of the situation in Palestine, being apartheid, colonialism, now genocide, and moving away from this Oslo paradigm that really prevented us from dealing with the realities to which Palestinians had been subjected for so many years, and not just the years of occupation of the West Bank and the Gaza Strip, but from the very beginning of the Israeli project in Palestine, going back to the Nakba and beyond, that there is no exception to international law, in spite of its assertion by the West, for Israel, that Israel is bound by the UN Charter, by international humanitarian law, by international human rights law, by international refugee law, and by international criminal law. And none of the excuses that have been provided to sort of carve out this Israel exception apply in international law. And this is not coming from a law review article, but coming from the World Court, the International Court of Justice. So I think historic is the right word. And when you put it together with other legal decisions that have come, so 20 years ago, the decision of the World Court on the illegality of the apartheid wall in the West Bank, and then subsequent developments, the current case with Israel being on trial for genocide in the International Court of Justice, and the provisional orders that have come out of that already, and the final much belated but much welcome move by the prosecutor of the International Criminal Court to request arrest warrants for senior Israeli leaders for crimes against humanity. You do see there is a certain momentum and a certain move, an irreversible move, I think, away from deferring the rights of the Palestinians to those who oppose those rights, because, if the Palestinians are compelled to negotiate for their rights with their occupier, with their oppressor, we've seen what that produces, which is just further erosion of their rights, or to defer to the Security Council, which is controlled by the United States and the UK and others with veto power, preventing the Palestinians from realizing their rights. Well, this is the new paradigm. This is the approach of international law, of international human rights, in which the Palestinians will always prevail because the law in this case is on their side, which is precisely why legal approach has been suppressed by Western powers for so long.
Well, how did you personally feel when you heard the ruling? And you kind of already answered this too. How significant is this ruling for Palestinians in the context of, international law and international community? You've has said in the past, Israel's current genocidal actions in Gaza are kind of eroding the world order established, post World War II. And so how did you feel hearing this ruling? How significant is it for Palestinians in the realm of international community, international law? But as you've seen, Israel's actions have kind of eroded international law. Them not respecting this decision, do you see it further eroding international law?
Yeah, unquestionably. I mean, first, how did I feel? I have to say I was not surprised. I always knew that if the court was not corrupted, and that's a big if, because we know by recent revelations, and we've known all along, that powerful states will use their influence by hook or by crook to try to prevent judges from ruling in this direction, both in the International Court of Justice and the International Criminal Court. And that's a real concern. But barring that kind of corruption of the court, we knew that the court would rule in this way because international law has always been clear on these questions. As I said, precisely the reason that international law has been shoved aside by Israel and the US and the UK is because they knew that international law comes down firmly on the side of the Palestinians. So I wasn't surprised. I was somewhat relieved, and I was very pleased that they affirmed what we knew about international law in this case. And I think it is important in the context that you just set out because, it's clear that there is this double standard, there is this hypocrisy with the articulation of rule of law concepts by Western states that don't ever respect the rule of law when it comes to, for example, Palestine. The double standard that we've seen with the West reaction to events in Ukraine vis-a-vis the Russian invasion on the one hand, and in Palestine on the other side, the corruption of the prosecution of the International Criminal Court by Western forces that have prevented it from acting for years on pending cases relating to Palestine. Corruption is a big word, but the influencing of Western powers and Israel and its lobby on United Nations mechanisms to silence them or to get them to equivocate on key issues relating to Palestine. What that has said to the majority of the people in the world, the global South, the international human rights community, the international peace community, the international justice community, international lawyers, is that it is not just Israel's actions that are on trial in all of these recent legal developments. It's also the entire international legal system itself. Because if a country can get away with widespread war crimes, crimes against humanity, ethnic cleansing, and genocide, broadcast in real time to the screens of people all around the world so that it's beyond denial, and get away with that vis-a-vis these international legal mechanisms, international law itself, then those mechanisms and those laws will not be sustained. The Genocide Convention will cease to be a relevant force in international law. The International Criminal Court will fade away into obscurity. The International Court of Justice will lose its legitimacy if it's not able to deal with this. The international human rights system, the UN and its mechanisms as well. So all of that, the post-war international legal order, is also on trial. Luckily, by and large, it's been holding. So on the one side, you've got the UN independent human rights mechanisms like special rapporteurs, commissions of inquiry, the treaty bodies. They have taken a very principled, law-based approach to defending the rights of the Palestinian people in the face of these attacks from the occupying power. You have the International Court of Justice, the World Court, which once again has shown itself to be independent enough to apply the law to the actual facts and to not be intimidated in that process. You had the International Criminal Court. So that was the International Court of Justice. You had the International Criminal Court, which has been affected by Western pressure and bias and corruption, but which is now emerging somewhat from that, enough for a request by the prosecutor for arrest warrants for Netanyahu and Gallant, but which is now backpedaling a bit because it's being influenced. And then you have whole mechanisms of the UN Secretariat that have been entirely silent because they are politicized under the direction of the Secretary General and political pressure from member states. And they have not been doing their job. The Genocide Prevention Office, Children in Armed Conflict, and so on. So while they have been unable to suppress the information that's been flowing forward, they have been reticent to do their job as they were designed to be. Overall, it looks like at this moment in history, international law, international human rights are prevailing. And that may sound strange when you look at the horrors that are being perpetrated in Gaza on a daily basis, where every international protection relating to human rights and humanitarian law are being violated on a daily basis with apparent impunity. But the fact that these mechanisms are now laying out the law, laying out the case, laying out the evidence, can build a foundation for accountability, and that itself is extraordinary, because Israel has enjoyed 76 years of absolute impunity. That the Israel exception has meant that with the protection of the US and other actors in the West, the UK, the European Union, the Germans, others, and UN actors to whom they are adjacent, Israel has literally gotten away with murder for all of these decades. That's changing. That's shifting. And I think that before too long, we will begin to see teeth applied to these decisions, both in the form of action by states, who, by the way, are obliged to take measures to ensure respect for international humanitarian law. The Geneva Conventions do not just require that each state respect those rules, but it imposes an obligation on every state to ensure respect by other parties over whom they have influence. So imagine the US and the UK vis-a-vis Israel. They have a lot of influence. They have chosen not to use it because they've been complicit in the genocide in Gaza and in the persecution of Palestinians in the West Bank and Jerusalem and inside of Israel, and even in the diaspora, where Palestinians standing up for their rights are being attacked by official mechanisms of government. But that obligation is there. They are obliged to do it. They're obliged, now the court has said very clearly, not to do anything that supports Israel's unlawful actions, its settlements, its investments there, its military installations in the occupied territories. That is a breach of international law, and action can be built on these things. And I think even more importantly, this is another step toward holding Israel accountable in the way that the international community held South Africa accountable during the apartheid years, in spite of South Africa's support by governments like the US and the UK, because civil society mobilized with boycotts and divestment and sanction and protests and education and legal actions against individuals, action in UN mechanisms, action in the General Assembly and beyond, to build a level of pressure that ultimately made it impossible for Western countries supporting apartheid in South Africa to continue with those policies. And here now we have additional tools in the arsenal of justice to bring the same pressure to bear on Israel, and therefore to have some level of accountability for the perpetrators in Israel and redress for the victims in Palestine.
So just going off what you just said about pressure and accountability, and like using past examples like South Africa, and noting the incredible influence the US has on Israel and how they've been directly involved in supporting its actions. Right now, as we're speaking, Prime Minister Netanyahu is addressing US Congress. He is in the US right now speaking to them. How does that move reflect on the US in light of the recent ICJ ruling on Israel's occupation and the ongoing genocide in Gaza? What are the implications of hosting him amidst these, significant international legal and humanitarian concerns?
Well, I think that's why they're doing it. I mean, speaking as an international lawyer, the only thing I can say is that the U.S. government, when it comes to international law, is a rogue state. The U.S. has never supported or deferred to international law in any case. It has cynically sometimes used mechanisms of international law to go after its adversaries, but it has never itself, even it found itself on the losing end of a world court ruling in the mining of the harbors of Nicaragua, 40 some years ago, and refused to respect the decision of the court. And it has consistently insulated Israel from any obligations or impact of the decisions of legal mechanisms for its accountability. So that when it comes to international law, the U.S. is a rogue state. The U.S. believes in something else, not in international law. And here I'm talking about the government of the U.S., but they and this is Democrat, Republican. It doesn't make any difference, which of the two parties are in power. They reject international law. Remember, the U.S., just to give you an example, there are 193 countries in the world. All of them except one have ratified the main human rights treaty that protects the rights of children, called the Convention on the Rights of the Child. Only one country in the world has not ratified that treaty, and that's the United States, which gives you a sense of its attitude toward international law. Instead, it insists on something that it calls the rules-based order. The rules-based order is a concept made up in the halls of the U.S. State Department that is more akin to a kind of imperial rule, Roman imperial rule, which is that we make the rules and you all have to follow them. That is in direct contradiction to the requirements of international law, beginning with the UN Charter, but also in the rules of international humanitarian law, international human rights law, international criminal law, and so on. So it's not surprising that the U.S. Government, taking that position, would use its official podiums and even its parliament, its Congress, to host somebody who is universally known to be and despised as somebody guilty of war crimes, crimes against humanity, and genocide, and for whom arrest warrants have been already officially requested by the prosecutor of the International Criminal Court. But Here's where the hope is. First of all, outside of that building, there are tens of thousands of people who have assembled to oppose the hosting of Netanyahu at the US Congress, not just surrounding the Capitol building where the speech is taking place, but also surrounding all of the main avenues and intersections of the city of Washington to obstruct that movement, the hotel where Netanyahu was staying. And that it's more than just a symbol. They are determined to take action to show that this is not something that is supported by the American people, by people of conscience. And you look at those protesters, they are Jews and Muslims and Christians and agnostics and indigenous people and younger persons and older persons and human rights activists and peace activists and labor unions. And in other words, it is a cross-section of American society and of the world that is standing up to say, we see your complicity in hosting this war criminal. We reject it, and you don't speak for us. And that, I think, is where the hope comes from for eventual enforcement, because that's what changed it in South Africa. It wasn't the governments of the US and the UK and Europe. It was civil society. It was activists and movements and churches and ordinary people who stood up and said, no, not for us. And we have seen an unprecedented reaction from the very heart of civil society in the US, in countries across Europe, across the global South, standing up and saying, no, we absolutely refuse, not in our name. We will resist this. We will not accept it. And that is going to change it. It's going to change things through boycotts and divestment and sanction and protest and prosecutions and education and ordinary people standing up to say, no, this is the first live-streamed genocide in the history of the world. And when you see the propagandistic nature of Western media in suppressing the truth in essentially a brownout of genocide, and the dissemination of Israeli propaganda by these media outlets, when you see the action by social media companies to suppress and shadow ban those who are speaking out, you see how much they understand that the truth is a threat to them and they must suppress that truth. But the truth is getting out. It's getting out through word of mouth. It's getting out through independent media like Mondoweiss and others, and it's getting out through social media that has not been suppressed. So I think that this is a shift, a historical shift. I think this latest advisory opinion of the World Court is a part of that, and I think there's a lot more to come.
Earlier this month, Israel announced the largest land seizure in the occupied West Bank in over 3 decades, essentially moving closer to annexing the West Bank. This recent ICJ ruling, how does it impact these actions by Israel? Do you expect them to stop? Is there any kind of immediate consequences to Israel with all of the settlement building that they're doing?
I mean, Israel rejects international law in its entirety. It will sometimes go through the motions of sending lawyers to represent their case, but you will see that their arguments are largely not legal arguments because they know they can't really prevail in legal arguments. So they will they will appear at proceedings of the International Court of Justice in order to make arguments to the Western public, not to try to convince them. They know that, but they also know that they expect that after 76 years of impunity, that impunity will continue because they are protected by the government of the United States and others. They will not succeed. And the reason is because, as I said, early on in our conversation, states will begin to take their legal obligations. Some states will begin to take their legal obligations seriously, and you will see that this inevitably will have economic impact on Israel and on its occupation of Gaza, the West Bank, East Jerusalem, and so on. And that will be something that they cannot ignore. Before this ruling was issued, there were states in Europe that could say, we don't agree that there is apartheid. We don't agree that the occupation is illegal. We don't agree that we can't sell goods produced in settlements. They can't say that now. And that's effectively decided. And, as I said, the next step needs to be, nothing will happen in the Security Council because of the US veto. We know that. So you can expect a resolution in the General Assembly of the United Nations that I hope, and I am hopeful, will include some measures that Israel will feel. So again, things that relate to sanctions of the kind diplomatic sanctions, consular sanctions, recommendations of economic sanctions, military embargoes. All of that could go in a resolution of that nature. Accountability mechanisms could be a part of that for Israeli perpetrators, as was done also in the case of South Africa. There may be some sort of discussion about how to deploy some meaningful protection. Israel will not allow a protection force in, but they could set up a protection mechanism, deploy it to the borders, as has been done in the past, and then when Israel is compelled to allow access, there may be some access there. There are a lot of measures that can be taken that could make a difference. It's also true that because these are war crimes, right? So the settlements are war crimes. And some of the other measures that were identified are war crimes, not to mention what's happening in terms of persecution of Palestinian people, not just in Gaza, but we have to remember this genocide is not only happening in Gaza, it's happening in all of the occupied Palestinian territories, arguably also inside the Green Line, and arguably the persecution of Palestinians and their defenders around the world at the behest of Israel, its lobby, and corrupted government officials, is also a part of the same persecution, part of the same genocide. And so you could begin to see consequences for that. Nobody is going to march into Tel Aviv and arrest anybody. But, Netanyahu has to think about where he travels now. He has to think about whether he has a connecting flight or a direct flight. And this is even before, the issuance of eventually an arrest warrant from the International Criminal Court, because a lot of these crimes are crimes under universal jurisdiction that could be prosecuted in a third-party court, in a third state court as well, where that has happened from time to time. You could see companies that are invested in the settlements going bankrupt or withdrawing intentionally to avoid the economic consequences. Little by little, you will see, I believe, as we did in South Africa, that it will become economically, politically, and legally impossible for Israel to maintain the course on which it finds itself. The U.S. is unlikely to change because of the nature of the political system and its corruption, but you will see changes amongst European countries, countries of the global South. It remains to be seen whether we see any meaningful changes in the surrounding Arab governments, which have been sadly complicit in the persecution of the Palestinian people, most recently with this tactic of the Abraham Accords, which is a way of buying off frontline states to prevent them from holding Israel accountable for the crimes it perpetrates against the Palestinian people. But even there, we could see some changes from public pressure eventually. And I think the thing to watch for now is what happens in the General Assembly. Do we get a meaningful resolution that has some of these measures that can have some teeth, or will Western pressure, threats, and carrots water that resolution down to the point where it's not meaningful, and then you just hear delegations at the UN or UN officials begin again to parrot, let's all work toward a two-state solution and get some humanitarian aid in, and that's it, without addressing the root causes or the legal rights and obligations that have been defined by the court.
Let's say that the second option happens. We get a watered-down resolution in the General Assembly. Do you see that undermining this historic ruling, or would you see the calls for BDS continue to grow, Israel still becoming isolated in the international community, and different ways for them to be held accountable?
I think that each individual state will do what it is made to do by people, and the UN will do what the states make it do. So the civil society mobilization, BDS, and all the things that go along with it is going to be essential to making sure that states do the right thing, both in their own affairs and as participants in the General Assembly and elsewhere in the UN, the Human Rights Council, and so on. But I am optimistic that pressure is being felt, that it will continue, and that it will grow. so that states will not be able to ignore the pressure that's coming from society. There is a universal horror at what's happening, which doesn't reflect the positions of government at all. If you just listen to the US and the UK and the German governments and others, you would think that those are their national positions. They are not. Those are the positions of governments that have been compromised by their own political shortcomings and the corruptions of their own systems. But across the world, people are horrified, and they are mobilized, and that mobilization is growing. And I think it will only continue to grow, and the pressure will reach the point where governments are unable to ignore it. So, none of this offers immediate term relief or hope to the suffering people of Palestine, but it offers hope on the horizon that wasn't there just a couple of years ago. And that's something, but it imposes an obligation on all of us to seize that, because it could well happen that you end up with a watered down resolution in the GA. That won't water down action by people and by civil society and by movements. It will only discredit the General Assembly, and it will only postpone the kinds of action that will ultimately come out of the General Assembly as well. But I don't know. I'm not giving up on what could come out of this. The GA cannot ignore what the court has said. The GA is the one who asked for this from the court, and they're going to have to find some way to give it effect. The court says explicitly that it now falls to the General Assembly to take the measures necessary to give effect to what it has found. And to give effect means to make Israel withdraw its forces, its settlers, its occupation infrastructure, its laws, its persecution from all of the West Bank, all of the Gaza Strip, all of East Jerusalem. And leaving open the unresolved issues about what happens inside of the Green Line, which are unresolved because they weren't requested to deal with that in this particular case, but that will come out as well. In the meantime, nobody can say that somebody who talks about apartheid, Israeli apartheid, or illegal occupation, or war crimes, crimes against humanity, genocide, that is just editorializing. These are legal positions that we all must be echoing to make sure that they're not ignored by states and by the UN.
Yeah, definitely. You brought this up a little bit when you spoke about Israeli lawyers and how they're responding to this. But a few Israeli international law experts are downplaying the significance of the ICJ's advisory opinion, noting that it's not non-binding and arguing that the court did not declare the occupation itself illegal, but rather focused on specific violations of the rules of occupation. Just curious, how would you respond to these views?
I think we dealt with the issue about non-binding. People say advisory opinions are not binding because they don't compel an individual state to take a particular action in the way that they do when it's a dispute between two states. The court said this is not a matter of dispute just between two states. This is not a bilateral or unilateral issue. This is an issue of international law that applies to all states. And so they decided on it. But the issues it decided on, as I said, are binding rules of international law that bind Israel and that bind all other states. So it's not that they're just opining on what should be. They are authoritatively declaring what the law requires, right? So in that sense, and as I said, some of these obligations are erga omnes, the two central ones. One is the denial of the self-determination of the Palestinian people, which the court found Israel is actively doing, imposes obligations erga omnes on Israel and other states to stop that. The prohibition of the acquisition of territory by force, also so-called erga omnes rule, is obligatory on all states, Israel and all other states. So you can't say that the international legal rules that they've identified are non-binding. They apply, and the court has gone further and said, these are the steps you need to take. You have to remove everything and everybody, and you have to compensate the people, the Palestinian people who have been affected, and you have to allow those who have been evicted to return, remedies and reparation, restitution, all of that kind of thing. That's what the law requires. they have said. So that's on that first issue of what's binding and what's not binding. The other claim that somehow they didn't find the occupation itself illegal, that's just, I don't know what to call that except to say it's a lie, because the court was quite intentionally very explicit on this point, that the occupation of any part of the West Bank, East Jerusalem, Gaza Strip is unlawful. And not that it's unlawful, but it has to be ended as quickly as possible. And that all of the justifications that were offered by Israel for this, including security claims, do not change the reality of their obligation to immediately end all of the occupation and all of its manifestations. So, you can, of course, advocates of Israel are going to try to downplay, to discredit. According to officials of the Israeli government, all the way up to the prime minister and to its lobbies in the West, the World Court, the International Court of Justice, the UN human rights mechanisms, Amnesty International, Human Rights Watch, B'Tselem, and everyone who stands up against the violations committed by Israel are anti-Semitic supporters of terrorism. These are not compelling arguments, right? This is just a kind of petulant, childish reaction to having been caught in your misdoings, your misbehavior. But as I said, they don't have a legal defense. You have to really get into the realm of fantasy or in the realm of exceptionalism that says, yeah, that's international law, but it doesn't apply to us, in order to try to take those arguments. And you can see, the Israeli contribution to this process was a very short document of a few pages, shorter than the Western powers like the U.S., the submissions of those countries that had invested more in this than the Israelis, because they know perfectly well that the law is clear, that the law of non-acquisition of territory by force is clear, that the law of self-determination is clear, that the Geneva Conventions are clear, that the court's own decision 20 years ago that the law was unlawful and the wall was unlawful and had it to be removed, which Israel, the court noted, has completely ignored. That's a matter of law, and it's clear. Clarity is there, and it's never been more clear than it is today, thanks to this advisory opinion of the World Court on all of these issues. So I don't think in the end they will seek a legal answer. They will seek a political and military answer. They will, as we know, send Benjamin Netanyahu to talk to the U.S. Congress and to get the members of the Congress to defend Israel and to prevent these decisions from having any impact. They won't succeed. They won't be able to prevent these decisions from having an impact because many states will implement them. The U.S. will not be one of them, but many other states will implement them. And you'll see consequences emerging from civil society through boycotts and divestment and sanction and so on.
I'm just curious if you have any critiques of the ICJ ruling and if you felt in any way it didn't go far enough or if it could have done more.
No, I mean, the ICJ did a very good job of answering the questions that were put to it by the General Assembly. So they have to stay within, for an advisory opinion, they have to stay within the boundaries, essentially, of what the court has. They're not constrained. If there's a limiting thing that would make the decision unfair, they can expand, but they're not going to go into issues. If they're asked a question about the occupied Palestinian territories, they're going to answer the question about the occupied Palestinian territories. They didn't address anything relating to anything inside the 1967 boundaries, the pre-67 boundaries. And those are unresolved questions as well, that also relate to acquisition of territory by force, going from partition to 67, that relate to the treatment of Palestinians inside of the Green Line, but they were not asked to do so, and that's why they didn't do it. So I don't have a critique for that. So they found, for example, that at least with regard to the occupied territories, the crime of apartheid is being perpetrated, racial segregation and apartheid, to use their exact language. But they didn't address the issue of apartheid inside of Israel because they weren't asked to deal with that geographic portion. But I think they provided a lot of clarity There was no equivocation. They didn't avoid any of the questions, and so I have no real critique of the way that the court decided or the way that it proceeded. They had a very robust discussion. They had a hearing. They allowed dozens of countries to provide their inputs as they do in these decisions, and then they issued a ruling which is firmly based on international law and not politicized. There's doctrine in there, like they say, and sometimes they'll do this to get broad agreement amongst the court members. They'll add stuff in there that's not a matter of law, but they do it. So, for example, in this decision, they mention the negotiations in Oslo and so on. I don't think anyone has any confidence in those processes anymore, but since it's been mentioned, but it's in Security Council resolutions and so on, they will say, and it would be good if, I forget what the exact language is, but it's not declaring any obligations in that regard. It's kind of doctrine, in there. So I think it's a very clear statement on the part of the court of what the law is and what it requires. And the ball is now in the court of the General Assembly and all of the rest of us to try to give effect to what the court has said.
So I just want to go back to this a little bit with Netanyahu speaking right now at Congress. Does the U.S. welcome him with open arms and, kind of the U.S. being a superpower that it is, does it undermine this ruling in any way?
I think the purpose is to try to undermine this ruling and other developments recently that have delegitimized the Israeli project. That's why they're hosting him. This is one of the few places in the world where they could have done that. I think a lot of other countries would have absolutely declined. They have the benefit of the fact that the arrest warrant for Netanyahu has not been issued yet. I suspect they would still welcome him. But, you hear talk about him having to take a direct flight because he's nervous about landing in other Western capitals. And that's only going to become more and more severe if arrest warrants are issued for him. But even if the prosecutor or the International Criminal Court, the other court, gives in to pressure or corruption and doesn't issue arrest warrants, I think his ticket is written by global civil society and by most countries of the world and by many of his own compatriots as well. And I think it's unlikely that he's going to have that freedom of movement that he has now for very long. And I don't think that people don't look at this and say, oh, the U.S. Congress has welcomed him, maybe he's legitimate. I don't think so. I think that only discredits the U.S. Congress and the U.S. government in the eyes of most people in the world who think this is horrific. One only need to go on social media these days to see the reaction that this person who is accused of war crimes, crimes against humanity, ethnic cleansing, and genocide is being given a VIP welcome in the Congress of the United States. Most people find that to be absolutely disgraceful. And it doesn't disgrace international courts or international human rights mechanisms. It disgraces the U.S. Congress and the U.S. government. It doesn't disgrace the U.S. people who are out in their tens of thousands protesting this disgraceful action on the part of the U.S. Congress. So the U.S. has invested a lot of political capital in ensuring Israeli impunity. The U.S. itself will begin to pay more and more of a tax for that, not just the billions and billions of dollars of taxpayer money that they give without strings to this oppressive foreign regime of Israel, but a loss of international standing, a loss of international influence, a loss of credibility, a loss of a voice on matters of international law, international human rights, and so on. They're paying an enormous tax. And it shows you the danger of political capture because it's not free for the U.S. government and the U.S. Congress. But they won't be able to stop this growing snowball of justice that has been building for years now and is only expedited with the genocide that has been taking place for the last 9 months. Not the U.S., not the UK, not the Germans or the European Union, not the Mossad, not the Israeli occupation forces. No force on earth is going to be able to stop this South Africa tsunami style tsunami that we see happening. And it's way too slow for Palestinians who are suffering the horrors of genocide. But justice is going to come.
I want to end on a last question here, like kind of a hopeful note. I mean, you've alluded to a lot of optimism for the future and, as you put it, the snowball of justice. What would you like to see as realistic next steps, either on a macro level or just like in the immediate term?
Well, I think we have to all make our voices heard and get a lot of public and private pressure out there to make sure that delegations in the General Assembly do the right thing with the kind of implementing resolution that needs to follow this development. I think that the mobilizations of civil society and movements that have been happening, that needs to be sustained and it needs to be increased so that that pressure from below is there. I think that we need to look at all of the options that are available to us because, again, the law is on our side and it's very clear. So I'd like to see more action for prosecutions in third state courts under universal jurisdiction for individual perpetrators, civil suits against the state of Israel for its harms that it has been causing in third-party courts as well. We have to keep the pressure on the International Criminal Court to act on the early steps that it has already taken toward holding some Israeli perpetrators accountable. We have to push for the anti-apartheid movement to become stronger and stronger. Boycott, divest, sanctions, prosecute, demonstrate, educate, all of those pillars of changing the reality as it is on the ground. We have to just sort of double our efforts to bring about what we know is inevitable, which is a just outcome to this. But first, General Assembly, and then everywhere else. And that implies an obligation on all of us, right? That's not to defer governments. If you defer to governments, they will not do the right thing ever, any government in any circumstances. It's pressure from the people that makes governments do the right thing when it comes to issues of human rights. So that's where that has to come from. And, continue building the movement. I mean, the solidarity between Jews and Christians and Muslims, in solidarity and under the leadership of the Palestinian people, and this coming together that we've seen of the peace movement and the human rights movement and the labor movement and the international legal movement and all of these. I mean, this is changing the equation. This is changing the incentive structures that have dominated for the past 76 years, and we just have to keep it up.
Thank you, Craig, for sharing your time and your knowledge with us. It was a pleasure speaking with you, and I hope next time we speak, it will be, another major development towards a just solution for Palestinians.
I hope so. I enjoyed talking. Thank you.
That's our show. Mondo Weiss is a nonprofit publication with no paywalls. If you would like to support our work, please go to mondoweiss.net/donate. Please leave a rating and review to help other listeners find the show. Subscribe to one of our free email newsletters so you can stay up to date on events in Palestine and related politics here in the U.S. and around the world. Finally, if you have any more feedback, send me an email at dave@mondoweiss.net. Thanks for listening. We'll be back soon with a new episode.